Your son or daughter are separated from their partner and you're not being allowed to see your grandchildren. What can you do? Well, to answer that question, I'm joined by family law barrister Malvika Jaganmohan from St Ives Chambers in Birmingham. Is this a common problem, Malvika?
I don't know if it's common. It's not unusual. The reality is families fall out for reasons that some of us may not understand. They may be petty reasons. They may be reasons that are more serious. But ultimately, it's not where we want to be. I think the first step to take is try and talk to the parents if you're a grandparent. Try and be introspective. Try and see what role you've played in that relationship breaking down. What reassurance can you give them so that you can rebuild your relationship with your child? That may be a hard pill to swallow, but you've just got to keep your mind on the end goal, which is having a relationship with the grandchild.
If matters have broken down so that the parents are simply refusing to let the grandparents have any contact at all, is there anything the grandparents can do?
Yes, they can suggest mediation. Mediation is obviously an independent professional, a mediator who talks to the various people involved and tries to help them reach an agreement. Before you make any application to the court will expect you to attend something called a MIAM, a Mediation Information and Assessment meeting, and that's a meeting where you are told what mediation is and how it can help you in your particular circumstances. So the ideal is that you can try and resolve things before ever needing to come to court. Mediation is often cheaper and quicker to access than court proceedings.
Is mediation paid for by the state, or do the grandparents have to fund it themselves?
You may be eligible for legal aid, so make sure that you look into that because that could potentially help you with the costs.
Let's assume the grandparents and the parents have gone through mediation, but no agreement's been reached, or for some reason or another, it's not being followed. What, if anything, is the next step that a grandparent can take to try to arrange some sort of contact with their grandchildren?
You can apply for something called a child arrangements order, which is an order that regulates the time that you spend with your grandchild. Now, the difference between a parent applying for a child arrangements order and a grandparent applying is that a grandparent doesn't have an automatic right to apply. They need the court's leave to apply first. In deciding whether or not to grant that leave, the court would have particular regard to the following things: the nature of the proposed application, the applicant's connection with the child, and any risk there might be of the proposed application disrupting the child's life to such an extent that they would be harmed by it. If the child is looked after by the local authority, the court would also have particular regard to the authority's plans for the child's future and the wishes and feelings of their parents. So if permission is granted, that's when the substantive application would be considered. It may not be resolved at one hearing, it may take several hearings, and the court's paramount consideration is the child's welfare. So is it in their best interest to have a relationship with you? Is it in their best interest to have that contact with you? Ultimately, it's not about your rights, it's not about the parents' rights, it's about what's in the best interest of the child.
Just before we continue, please do like this video if you're finding it useful. It means other people will be able to find it using the YouTube search algorithm. Malvika, if the grandparents want to make an application to the court, what's the specific form that they should use?
It would be a C100 form, which will be available on the government website.
Thank you. We'll add a link to the C100 form in the notes below. Let's assume that the court orders some level of contact, but the parents just continue to refuse to allow it and ignore the court order. What options do the grandparents have in that situation?
Worst case scenario, and hopefully you won't need to resort to this, if they continue to obstruct the order, then you should try and speak to them informally and say, is there a reason why the order isn't being respected? But if they continue to disrupt the arrangements, then you can apply to the court to enforce the order, because there is a very clear warning on a child arrangements order that it needs to be complied with, and there can be consequences for it not being complied with. So worst case scenario, you can apply to the court for an enforcement order.
But presumably that's just going to make things worse in the long term?
Well, ultimately, parents cannot just seek to not respect court orders because they don't feel like it. They've had an opportunity to make their representations, they've had an opportunity to tell the court their views, and the court has made an order which it thinks is in their best interest. And there are sanctions available to the court if a parent does not comply with an order.
Malvika Jaganmohan, thank you very much. If you found this guide useful, please do subscribe to my YouTube channel where I have a whole series of explainer guides on English law. It covers family law, criminal law, employment law, and we're adding a whole range of other areas over the coming weeks and months. Thank you so much for watching. I'm Barrister Daniel Barnett. Bye-bye.